Chapter 5 of the South African Law of Persons, 6th edition by Jacqueline Heaton. The topic of Chapter 5 is Children Born of Unmarried Parents. Under Chapter 5 we have 5.1 Introduction, 5.2 Definition of children born of married parents in quotes and children born of unmarried parents in quotes. 5.3 Categories of children born of unmarried parents. 5.3.1 Introduction. 5.3.2 Natural children. 5.3.3 Adulterine children. 5.3.4 Incestuous children. 5.4 Artificial fertilization. 5.4.1 Meaning of artificial fertilization in quotes. 5.4.2 Status of a child who is born as a result of artificial fertilization. 5.4.3 Relationship between the child and the birth mother, and between the child and the person whose gamete was used for the artificial fertilization. 5.5 Proof of parentage. 5.5.1 Introduction. 5.5.2 Presumptions of paternity. 5.5.3 Corroboration of the mother's evidence. 5.5.4 Factors which may be relevant in proving paternity or rebutting a presumption of paternity. 5.6 The legal relationship between a child and his or her unmarried parents. 5.6.1 Introduction. 5.6.2 Definition and components of parental responsibilities and rights. 5.6.3 Parental responsibilities and rights of the mother. 5.6.4 Parental responsibilities and rights of the father. 5.6.5 General rules on exercising parental responsibilities and rights. 5.6.6 The position if both unmarried parents have parental responsibilities and rights. 5.6.7 Succession. 5.7 Changing the status of a child born of unmarried parents. 5.7.1 Introduction. 5.7.2 A subsequent marriage between the child's parents. 5.7.3 Adoption. 5.7.4 An order of the authorities. Chapter 5 is covered in pages 49 to 83. Please note, Chapter 5 is recorded in two parts. This is part 1, which is from the pages 49 to 66, and part 2 will be from the pages 67 to 83. 5.1 Introduction. In the past, our law categorized children as either legitimate, in quotes, or illegitimate, in quotes. And in brackets, illegitimate children are the children born out of wedlock or extramarital children. The Children's Act 38 of 2005 steers away from these negative, hurtful terms. Instead, it describes parents with reference to their marital status and uses this criterion to regulate the acquisition of parental responsibilities and rights. Thus, the Act refers to a married or an unmarried father, a married or an unmarried mother, a married or an unmarried person, and married parents. See footnote 1. Consequently, the terms child born of married parents in quotes and child born of unmarried parents in quotes are the more up-to-date descriptions, and they are used in this book. Originally, illegitimate, in quotes, children suffered from a number of legal disabilities, and the rules relating to their parents' responsibilities and rights differed markedly from those that applied to the responsibilities and rights of parents of legitimate children. Gradually, the law began to reduce these legal differences. As appears from the discussion below in this chapter, the law still does not treat unmarried and married parents in exactly the same way. Now, however, the law grants the same parental responsibilities and rights to certain unmarried fathers that it grants to married fathers and to mothers. 5.2 Definition of children born of married parents, in quotes, and children born of unmarried parents, in quotes. A child born of married parents is a child who is born of parents who are legally married to each other at the time of the child's conception or birth or at any intervening time. See footnote 2. The Children's Act defines marriage in broad terms that include civil, customary, and religious marriages. See footnote 3. In terms of the Civil Union Act 17 of 2006, civil unions are also covered by the term marriage. See footnote 4. Thus, a child who is born of civil union partners is also a child born of married parents. In view of the provisions of the Civil Union Act, and for the sake of simplification, the remainder of the chapter will refer to marriages as encompassing civil unions, unless the context requires otherwise. If a child's parents are not married to each other at the time of the child's conception or birth or at any intervening time, the child is a child born of unmarried parents. 5.3 Categories of children born of unmarried parents. 5.3.1 Introduction. Traditionally, 3 different categories of children born of unmarried parents were distinguished. The differences between these categories are of little importance in modern law. Their only relevance is that an incestuous child will usually not be able to acquire the status of a child born of married parents because the child's parents will usually not be able to marry each other after the child's birth. 5.3.2 Natural children. Natural children are born of parents who, though not married to each other at the time of the child's conception or birth or at any intervening time, could validly have married each other. 5.3.3 Adulterine children. In the case of an adulterine child, one or both of the child's parents were married to someone else at the time of the child's conception. 5.3.4 Incestuous children. Incestuous children are born of parents who could not have married each other at the time of the child's conception because they were too closely related. So just as a note of interest, the word incestuous is taken from the noun incest, which speaks of a sexual act or sexual activity between two people who are too closely related or who are classed as too closely related to ever get married. 5.4 Artificial fertilization. 5.4.1 Meaning of artificial fertilization in quotes. Artificial fertilization refers to the introduction by artificial in quote means, in other words, not by way of sexual intercourse, of a male gamete into the internal reproduction organs of a woman for the purpose of human reproduction. A gamete is either of the 2 generative cells essential for human reproduction, in quotes, that is, a sperm and an ovum. See footnote 5. Artificial fertilization also includes the joining of a male and female gamete outside of the human body with a view to replacing the product in a woman's womb, as well as the actual placing of such products in a woman's womb. That is in vitro fertilization. See footnote 6. The definition of artificial fertilization is wide enough to cover surrogate motherhood or surrogacy. Surrogate motherhood refers to the situation where the surrogate mother undertakes to be artificially fertilized for the purpose of bearing a child for the commissioning parents and handing that child over to the commissioning parents upon the child's birth or within a reasonable time thereafter, so that the child will become the commissioning parent's child if he or she were born of the commissioning parents. See footnote 7. A commissioning parent is the person who enters into a surrogate motherhood agreement with the surrogate mother with the object that the surrogate mother will be artificially fertilized and will bear a child for the commissioning parent. See footnote 8. Because the word artificial has negative connotations, this type of fertilization is nowadays usually called assisted fertilization or assisted reproduction. However, as the current discussion relates mainly to the rules set out in the Children's Act, the discussion below uses the term the legislature employs in the Act, that is, artificial fertilization, in quotes. 5.4.2 Status of a child who is born as a result of artificial fertilization. If a child is born as a result of the artificial fertilization of an unmarried woman, he or she is a child born of unmarried parents. If the woman is married and the sperm of her husband was used for the artificial fertilization, the child is a child born of married parents. This is the position regardless of whether or not the woman's husband consented to his sperm being used. See footnote 9. If a donor's gamete, that is a sperm or an ovum of a third party, was used for the artificial fertilization of a married woman, the child is a child born of married parents only if both spouses consented to the artificial fertilization. See footnote 10. If one of the spouses did not consent to the use of a donor's gamete, the child is a child born of unmarried parents. Because consent is presumed to have been given, see footnote 11, anyone who alleges that it was absent bears the onus of proof. So here, onus of proof is like a burden of proof, which requires a party to produce evidence to establish the truth of facts needed to satisfy all the required legal elements of the dispute. Prior to the coming into operation of Section 40 of the Children's Act, the decision of the Constitutional Court in J versus Director General of the Department of Home Affairs, see footnote 12, placed a child who was born as a result of the artificial fertilization of a same-sex life partner in the same position as a child born as a result of artificial fertilization of a married woman. However, Section 40 of the Children's Act subsequently reenacted the law as it was before J was decided. Consequently, if same-sex life partners who fall outside the ambit of the Civil Union Act have a child as a result of the artificial fertilization of one of them, the child now is a child born of unmarried parents. And just quickly here, ambit means the scope, extent, or bounds of something. This position will be corrected if the amendment of the section envisaged in Clause 21 of the Children's Amendment Bill 18 of 2020 were to become law. 5.4.3 Relationship between the child and the birth mother and between the child and the person whose gamete was used for artificial fertilization. A. Artificial fertilization without surrogate motherhood. The woman who gives birth to a child who was conceived as a result of artificial fertilization is for all purposes regarded as the child's mother, unless she is the child's surrogate mother in terms of a valid surrogate motherhood agreement. See footnote 13. The position that applies in the case of surrogate motherhood is discussed under the next heading below. The present discussion focuses on artificial fertilization without surrogate mothers. The starting point in respect of the relationship between a child who is born as a result of artificial fertilization and a person whose gamete was used for the artificial fertilization is that no rights, responsibilities, duties or obligations arise between the child and the person or between the child and the person's blood relations. See footnote 14. This rule is subject to an exception, namely, it does not apply if the person is the child's birth mother or her spouse. See footnote 15. If the exception applies, the ordinary rules of the law govern the relationship between the child and the person and between the child and the person's blood relations. This means, for example, that if the sperm of the birth mother's husband was used, she and her husband have all the rights, responsibilities, duties, and obligations that married parents have in respect of their child. If the birth mother is unmarried, she has all the rights, responsibilities, duties, and obligations that a mother has, while the sperm donor has no rights, responsibilities, duties, and obligations unless he qualifies as an unmarried father who has parental responsibilities and rights. See footnote 16. According to Collar J in QG versus CS, see footnote 17, the purpose of the rule which excludes a donor from acquiring rights, responsibilities, duties, or obligations in respect of the child is to make it so that in the eyes of the law, a donor-conceived child is the child of the person or persons who intended to act as the child's parents or parents, in quotes. Although the general rule is that no rights, responsibilities, duties, or obligations arise between the child and the gamete donor, Section 41, subsection 1 of the Children's Act entitles the child or his or her guardian to access medical information concerning the child's genetic parents. See footnote 18. Once the child has turned 18, he or she or his or her guardian may obtain any other information concerning the genetic parents. See footnote 19. The information may, however, not reveal the identity of the genetic parents. See footnote 20. The Act does not define the term genetic parents, in quotes. In its ordinary sense, the term refers to the man and the woman whose genetic contributions, sperm and ovum, merged to form the fetus from which the child developed. B. Artificial fertilization of a surrogate mother. Read footnote 21. Point 1. Introduction. The Children's Act sets requirement for and regulates the consequences of surrogate motherhood. As the present chapter focuses on the status of a child who is born of unmarried parents, the requirements for surrogate motherhood falls outside its scope. Some of the most important requirements are nevertheless mentioned below to facilitate a better understanding of legally recognized surrogate motherhood. 1. Surrogate motherhood may not take place for commercial reasons or be a source of income for the surrogate mother. See footnote 22. In other words, commercial surrogacy is prohibited, but altruistic surrogacy is allowed. Altruistic surrogacy is a form of surrogacy where a surrogate mother carries a child for another individual or couple without financial compensation beyond the reimbursement of pregnancy-related pregnancies. So this is basically a practice that emphasizes the surrogate's unselfish act of generosity, which is very different from the commercial surrogacy. 2. Spouses, same-sex or heterosexual life permanent partners, or a single person may be commissioning parents, provided that they are, or he or she is, permanently, irreversibly unable to give birth. See footnote 23. 3. The parties must conclude and sign a valid surrogate motherhood agreement which must be confirmed by the court. Read footnote 24. 4. The surrogate mother may not be artificially fertilized until the agreement has been confirmed by the court. See 25. 5. The gametes of both commissioning parents must be used for the artificial fertilization of the surrogate mother. If this is not possible due to biological, medical, or other valid reasons, the gamete of at least one of them must be used. In other words, surrogate motherhood cannot validly take place unless the child who is to be born has a genetic link to at least one of the commissioning parents. If the commissioning parent is a single person, his or her gamete must be used. See footnote 26. In AB versus Minister of Social Development, see footnote 27, the Constitutional Court confirmed that this genetic link requirement does not violate the Constitution of the Republic of South Africa, 1996. Point 2. Relationship between the child and the birth mother, and between the child and the commissioning parent or parents. If the parties concluded a valid surrogate motherhood agreement, the child is deemed to be the child of the commissioning parent or parents for all purposes as from the moment of his or her birth. See footnote 28. If the commissioning parents are married, the child is a child born of married parents. If the commissioning parent is unmarried, the child is a child born of unmarried parents. No rights, responsibilities, duties, or obligations arise between the surrogate mother and the child, even if her ovum was used for her artificial fertilization. See footnote 29. The surrogate mother, her spouse or partner in a permanent relationship, and her relations may, however, have contact with the child if the surrogate motherhood agreement permits it. See footnote 30. Furthermore, the child or his or her guardian may have access to medical information concerning the child's genetic parents. See note 31. Once the child has turned 18, he or she or his or her guardian may also obtain other information concerning genetic parents, but the information may not reveal the identity of the surrogate mother or the persons whose gamete was used for the artificial fertilization. See both footnote 32 and 33. If the surrogate motherhood agreement is valid, the surrogate mother is for all purposes deemed to be the child's mother, and the child has no relationship with the commissioning parents, regardless whether either or both of them donated gametes for the surrogate's mother artificial fertilization. See footnote 34. Point 3. Termination of the surrogate motherhood agreement. A surrogate mother whose ovum was used for her artificial fertilization may terminate a valid surrogate motherhood agreement by filing a written notice with the court within 60 days after the child's birth. See footnote 35. In other words, in the case of partial surrogate motherhood, the surrogate motherhood agreement may be terminated by the surrogate mother up until 60 days after the child's birth. If the termination occurs before the child's birth, the surrogate mother and her spouse or partner in a permanent relationship become the child's parents from the moment of the child's birth. If the surrogate mother does not have a spouse or partner in a permanent relationship, she and the commissioning father become the child's parents from the moment of the child's birth. See footnote 37. If the agreement is terminated after the child's birth, the surrogate mother and her spouse or partner become the child's parents from the date of the termination. If the surrogate mother does not have a spouse or partner, she and the commissioning father become the child's parents from the date of the termination of the agreement. See footnote 38. Regardless of whether the agreement is terminated before or after the child's birth, the surrogate mother and her spouse or partner, or the surrogate mother and the commissioning father, if the surrogate mother does not have a spouse or partner, are obliged to accept parenthood. See footnote 39. Therefore, the termination of the agreement cannot result in the child being left parentless. A surrogate mother may also terminate a surrogate motherhood agreement by terminating her pregnancy in terms of the Choice on Termination of Pregnancy Act 92 of 1996. Such termination obviously does not affect the child's relationship with either the surrogate mother or the commissioning parents, for the child is never born and thus never acquires a relationship with anybody. 5.5. Proof of parentage. 5.5.1 Introduction. The issue of who a child's parent is arises most often in the context of a dispute about paternity. Most reported cases therefore deal with matters relating to proving whether a particular man is a child's father and not whether a particular woman is the child's mother. However, the question of who the child's mother is may arise, for example, if a baby has to reveal the identity of the surrogate mother or the persons whose gametes were used for the artificial fertilization. See footnote 33. If the surrogate motherhood agreement is invalid, the surrogate mother is for all purposes deemed to be the child's mother, and the child has no relationship with the commissioning parents, regardless of whether either or both of them donated gametes for the surrogate mother's artificial fertilization. Point 3. Termination of the surrogate motherhood agreement. A surrogate mother whose ovum was used for her artificial fertilization may terminate a valid surrogate motherhood agreement by filing a written notice with the court within 60 days after the child's birth. See footnote 35. In other words, in the case of a partial surrogate motherhood, see footnote 36, the surrogate motherhood agreement may be terminated by the surrogate mother up until 60 days after the child's birth. If the termination occurs before the child's birth, the surrogate mother and her spouse or partner in a permanent relationship become the child's parents from the moment of the child's birth. If the surrogate mother does not have a spouse or partner in a permanent relationship, she and the commissioning father become the child's parents from the moment of the child's birth. See 37. If the agreement is terminated after the child's birth, the surrogate mother and her spouse or partner become the child's parents from the date of the termination. If the surrogate mother does not have a spouse or partner, she and the commissioning father become the child's parents from the date of the termination of the agreement. See footnote 38. Regardless of whether the agreement is terminated before or after the child's birth, the surrogate mother and her spouse or partner, or the surrogate mother and the commissioning father, if the surrogate mother does not have a spouse or partner, are obliged to accept parenthood. See footnote 39. Therefore, the termination of the agreement cannot result in the child being left parentless. A surrogate mother may also terminate a surrogate motherhood agreement by terminating her pregnancy in terms of the Choice on Termination of Pregnancy Act 92 of 1996. See footnote 40. Such termination obviously does not affect the child's relationship with either the surrogate mother or the commissioning parent or parents, for the child is never born and thus never acquires a relationship with anybody. 5.5 Proof of Parentage. 5.5.1 Introduction. The issue of who a child's parent is arises most often in the context of a dispute about paternity. Most reported cases therefore deal with matters relating to proving whether a particular man is a child's father and not whether a particular woman is a child's mother. However, the question of who the child's mother is may arise, for example, if a baby has been abandoned, if babies were switched after birth, see footnote 41, if a child has been abducted in some cases of assisted reproduction, and if a transgender person gives birth. See footnote 42. Because paternity is in dispute more often than maternity, two presumptions of paternity have been created. One applies in respect of the child of a married woman, and the other applies in respect of the child of an unmarried woman. These presumptions are discussed under the heading below. Although parentage is usually based on the fact of being genetically related to the child, Section 1, Subsection 1 of the Children's Act expressly excludes three categories of persons from legally qualifying as a child's parent. In quotes. They are 1. The biological father of a child who was conceived through rape of or incest with the child's mother. 2. Any person who is biologically related to a child by reason only of being a gamete donor for purposes of artificial fertilization. See footnote 43. 3. A parent whose parental responsibilities and rights in respect of the child have been terminated. Thus, for example, a man whose child was conceived as a result of him raping the child's mother does not qualify as the child's parent in terms of the Act and does not acquire any parental responsibilities and rights by virtue of the genetic link between him and the child. In M versus V, born N, see footnote 44, a mother alleged more than 9 years after her child was born that the child's father had raped her and that the child had been conceived as a result of rape. This allegation was first made after the mother became involved with another man whom she eventually married. Although the alleged rapist had been registered as the child's father shortly after the child's birth, had contributed to the child's maintenance, had had contact with the child by agreement with the child's mother, had been involved in major decisions regarding the child's upbringing until the breakdown of the parents' relationship, many years after the child's birth and had been involved in consulting professionals regarding the child's need for almost a decade, the mother wanted him to be excluded as that child's father by virtue of the definition of parent, in quotes, in Section 1, subsection 1. The court held that instead of making a blanket finding about the exclusion of the alleged rapists, it had to decide whether it is in the best interest of the particular child for his father to be recognized as a biological father who has parental responsibilities and rights in terms of the Act. The court based its decision on Section 39, subsection 2 of the Constitution, which dictates that the court must promote the spirit, purport, and object of the Bill of Rights when it interprets legislation. In this case, the child's constitutional right to parental care, to have paramountcy afforded to his or her best interests, and to dignity also had to be taken into consideration. See footnote 45. The court further referred to Section 6, subsection 2, paragraph A of the Children's Act, which inter alia provides that, subject to lawful limitation, the court must in all proceedings concerning a child respect, protect, promote, and fulfill the child's rights set out in the Bill of Rights, the best interest of the child standard, and the rights and principles set out in the Act. See footnote 46. In view of the facts of the case, and in particular the mother's acceptance of the man as the child's father for almost 10 years, the man's de facto exercising of parental responsibilities and rights during that period, and most importantly, the child's recognition of the man as his father for the whole duration of his life, the court concluded that it was not in the child's best interest to exclude the alleged rapist from having parental responsibilities and rights. The court did, however, specifically state that in another case, another court might arrive at a different conclusion on different facts. Just quickly, when we refer to the man's de facto, as we have mentioned above, de facto is a Latin word that is used to describe in fact or to describe in reality. So it describes a situation or status that exists in practice, even if it is not officially recognized or sanctioned by the law. 5.5.2 Presumptions of paternity. A child born of a married woman. If a woman is legally married at the time of her child's conception or birth or at any intervening time, it is presumed that the woman's husband and not some third party is the child's father. This presumption is expressed in the maxim pater est quim nuptiae demonstrant, that is, the marriage indicates who the father is. See note 47. As Section 20 of the Children's Act, which confers parental responsibilities and rights on married biological fathers, expressly refers only to biological, in quotes, fathers, and not all married fathers. It might be argued that the section qualifies or replaces the common law pater est quim nuptiae demonstrant presumption by conferring parental responsibilities and rights only on those married fathers who have proved their biological paternity. See footnote 48. In my view, it is unlikely that the courts would interpret the reference to biological fathers in Section 20 in this manner, for the logical corollary would be that all mothers would have also to prove their maternity before they could acquire parental responsibilities and rights in terms of Section 19 of the Act. Section 19 confers parental responsibilities and rights on a child's biological mother, and artificial fertilization and surrogacy imply that the child's birth mother might not be the child's biological mother. So here, just quickly, the term corollary would mean a proposition that follows from and is often appended to one already proved. Consequently, the child could be left without having any holder of parental responsibilities and rights at the time of his or her birth, even for some time afterwards, which is clearly not in the child's best interests. It is submitted that the use of the word biological, in quotes, in section 20 should be reconciled with the pater esquim nuptiae demonstrant presumption by reading the reference to the father, in quotes, pater, in the presumption as referring to biological father, in quotes. Thus, the mother's husband is presumed to be the biological father of the child. See footnote 49. The pater esquim nuptiae demonstrant presumption can be rebutted by evidence that the husband is, in fact, not the child's father. In other words, by evidence that the child was born of unmarried parents. The child's mother and or her husband can rebut this presumption by, for example, proving that they did not have sex with each other during the period when the child was conceived. See footnote 50. This must be proved on a balance of probabilities. See footnote 51. The right to rebut the presumption does not lapse in the course of time, and the presumption can be rebutted at any time. See footnote 52. Any interested person can rebut the presumption, and not only the child's mother or her husband. See footnote 53. Thus, for example, the child might want to rebut the presumption if this would enable him or her to inherit. In the past, our courts have been hesitant to declare a child who was born of a married woman to be illegitimate, end quote. See footnote 54. For example, in F versus L, see footnote 55, a man applied for an order declaring him to be a child's father while the child's mother was married to another man. The court dismissed the application because it found that it would not be in the child's interests to be declared illegitimate, end quote. Judge Harms held that the mother's husband was presumed to be the child's father by virtue of two presumptions. Firstly, the presumption pater esquim nuptiae demonstrant applied, and he was thus presumed to be the child's father. Secondly, the husband also admitted that he had had sex with the child's mother during the period of conception. Thus, the presumption of paternity following upon an admission of sex also applied to him. It should, however, be noted that the presumption of paternity which follows upon an admission of sex with the child's mother actually only applies when the mother is unmarried. See footnote 56. In this case, where the mother was married, only the pater esquim nuptiae demonstrant presumption should have been applied. Judge Harms was therefore incorrect in holding that both presumptions operated in respect of the mother's husband. See footnote 57. The court's conservative approach is also evident from B versus E. See footnote 58. In this case, the mother of a child who was born during the subsistence of a marriage wanted to have the child declared to have been born of unmarried parents. The mother applied for the appointment of a curator ad litem to investigate whether the child was born of married or unmarried parents. And now just quickly, we had previously said the curator ad litem is a person appointed by a court to represent someone who is unable to represent themselves in legal proceedings. The application was dismissed because the court found that it would not be in the child's best interests to be declared to have been born of unmarried parents. The pater est quim nuptiae demonstrant presumption applies to children conceived before a marriage but born during its existence, and to children conceived during the marriage but born after its dissolution. Thus, if a woman remarries shortly after the dissolution of her previous marriage and the presumption is consistently applied, both men could be considered the father of a child born during the early stages of the new marriage. In such event, it is rebuttably presumed that the new husband is the child's father. See footnote 59. Although see footnote 60, only refers to cases where the previous husband had died, there seems to be no reason why this rule should not be applied to all cases where the previous marriage is dissolved, irrespective of the cause of its dissolution. In terms of Section 13, subsection 1 of the Civil Union Act, the legal consequences of a civil marriage apply to a civil union, with such changes as may be required by the context, in quotes. Whether this means that an adapted version of the pater est quim nuptiae demonstrant presumption must be applied to same-sex civil unions is unclear. The presumption specifically refers to a father, while there are two male or two female parties, that is, two fathers or two mothers in a same-sex civil union. Furthermore, in the case of a same-sex civil union, procreation necessarily involves artificial fertilization, and in the case of a male couple, it involves surrogate motherhood too, unless, of course, the child is conceived through an adulterous relationship with a third party of the opposite sex. As the rules regarding artificial fertilization and surrogate motherhood usually determine who the child's parents are in the case of the same-sex civil union, application of an adapted version of the presumption to such a civil union is probably not viable. See footnote 61. B. A child born of an unmarried woman. In terms of Section 36 of the Children's Act, a man is presumed to be the biological father of a child who is born of an unmarried woman only if it is proved that he had sex with the child's mother at the time when the child could have been conceived. See footnote 62. Like the pater est quim nuptiae demonstrant presumption, this presumption is rebuttable. The presumption operates in the absence of evidence to the contrary, which raises reasonable doubt. Normally, the onus of proof or rebuttal in civil matters is proof or rebuttal on a balance of probabilities. See footnote 63. Requiring evidence to the contrary, which raises a reasonable doubt, in quotes, as Section 36 does, is a departure from the ordinary rule. See footnote 64. It also creates a discrepancy when compared to the onus that applies in respect of rebutting the pater est quim nuptiae demonstrant presumption, because the latter presumption may be rebutted on a balance of probabilities. See footnote 65. It is submitted that this discrepancy amounts to an infringement of the right to equality before the law and equal protection and benefit of the law, because an unmarried man must discharge a heavier burden of proof than a married man has to. A child who was born of an unmarried woman and who wanted to attack the discrepancy on constitutional grounds could also rely on his or her right not to be subject to unfair discrimination on the ground of birth, while an alleged father who wanted to attack the discrepancy could also rely on his right not to be subject to unfair discrimination on the ground of marital status. See footnote 66. There does not seem to be any justification for any of these limitations of the right to equality. See footnote 67. Any acceptable evidence suffices to rebut the presumption, regardless of whether it is correct or circumstantial. See footnote 68, provided, of course, that it is sufficient to raise a reasonable doubt. 5.5.3 Corroboration of the mother's evidence. As far as proof of sexual intercourse is concerned, the courts formally did not accept the mother's evidence without corroboration. See footnote 69. So just a quick note here. Corroboration in law is independent evidence that strengthens, supports, or confirms another piece of evidence, such as a witness's testimony or a statement, by adding credibility and weight to it. So in terms of this, that's the corroboration that we are speaking of. This rule was rejected by the then Appellate Division, now the Supreme Court of Appeal, in Mayer v. Williams. See footnote 70. The court pointed out inter alia that the rule is based on a misunderstanding of Roman Dutch law and that it is an anomaly that in such instances there is a heavier burden of proof in civil cases than criminal matters. The court, however, stated that in paternity cases, the mother's evidence should be carefully scrutinized. In this regard, the judge referred to the cautionary rule in criminal proceedings concerning sexual offenses. See footnote 71. He could see no reason why the same rule should not be applied in civil proceedings. The cautionary rule requires the court to recognize the inherent danger of relying on a complainant's evidence in respect of a sexual offense and also to recognize the need for some safeguard reducing the risk of a wrong conviction. Such a safeguard may be found in corroboration, the absence of contradictory evidence, or the untruthfulness of the accused as a witness. Therefore, the plaintiff's testimony does not always require corroboration, but corroboration may serve as a safeguard. The decision in Mayer v. Williams in respect of application of the cautionary rule to women's testimony in paternity suits will most probably not be followed in future because the cautionary rule has been abolished in respect of sexual offenses. See footnote 72. Section 60 of the Criminal Law, Sexual Offenses and Related Matters Amendment Act 32 of 2007 provides that a court may not treat the evidence of a complainant in respect of a sexual offense with caution because the evidence relates to an offense of a sexual nature. 5.5.4 Factors which may be relevant in proving paternity or rebutting a presumption of paternity. A. Absence of sexual intercourse. If it can be proved that the man who is presumed to be the child's father did not have sex with the child's mother at any time when the child could have been conceived, for example, because he is impotent or was elsewhere at the time, the presumption of paternity is rebutted. See footnote 73. B. The gestation period. To establish who a child's father is, it is often necessary to determine the period of gestation. In our law, there is no fixed gestation period. So just quickly, the gestation period is the length of time from conception to birth, during which a fetus develops inside the woman's womb or the body. So that's what we are referring to here. The courts make a decision on an ad hoc basis, sometimes relying on medical evidence as to when conception could have taken place, other times taking judicial notice of the normal, in quotes, period of gestation. So another note here quickly, just out of interest, when we say ad hoc or on an ad hoc basis, it means doing something only when necessary for a specific immediate purpose and without any prior planning. See footnote 74. The normal period of gestation is more or less 270 to 280 days, but as is indicated above in this chapter, the courts have adopted a conservative approach towards declaring a child to have been born of unmarried parents. As a result, long periods of gestation have been accepted. In Williams v. Williams, see footnote 75, for example, the court, in the absence of medical evidence, was not prepared to hold that 11 months were too long. And in Mitchell v. Mitchell, see footnote 76, a gestation period of 320 days was accepted. In contrast, it has been held that a gestation period of only 206 days was impossible. See footnote 77. However, with advances in medical treatment for and increased survival rates of even very premature babies, the courts may in future revise their view on the minimum period of gestation. C. Sterility. Proof of sterility obviously shows that the man is not the child's father. See footnote 78. D. The exceptio plurium concubentiam. Sometimes a man admits that he had sex with a woman during the time the child could have been conceived, but then proves that the woman also had sex with another man or other men during that period. This defense is known as the exceptio plurium concubentiam. Although our common law authors are not unanimous on the exceptio plurium concubentiam, and the appellate division left the issue of the applicability of the exceptio in modern law open in S v. Swart, see footnote 79. The generally accepted view nowadays is that the exceptio does not form part of our law. See footnote 80. Accordingly, it is of no avail to a man to prove that other men also had sex with the child's mother. It must be noted that this approach gives rise to problems. Suppose, for example, that the woman points out A as the child's father and A proves that he is sterile. Can the woman now point out B? In F versus L, see footnote 81, it was said that the woman's selection is presumably irrevocable, in quotes, and that a man is absolved from liability for maintenance once the mother has selected another man as a father. In other words, once she has named A as the father, B can rest assured that he cannot later be named as the child's father. However, it must be borne in mind that the child's best interests should be paramount. See footnote 82. It is not in the best interests of the child completely to exclude the possibility of the child's having a maintenance or succession claim against a man, B, or the estate of a man who might actually be the child's father just because the child's mother has named another man, A, as the child's father. Therefore, it is submitted that the child should not be bound by the choice his or her mother has made in respect of naming a particular man as his or her father. What is the position if a man, other than the one the mother has named, wants to prove that he is the child's father? This question also arose in F versus L. In this case, a woman had had sex with two men during the period when conception could have occurred. She married one of them. A few years later, the other man applied for an order declaring him to be the child's father. The court held that, in such a case, the law gives the mother the right to choose or appoint, in quotes, the father. See footnote 83. Here, she had chosen her husband, and the other possible father could not interfere with the choice. Judge Holmes stated, "I know of no principle that gives the jilted lover the right to interfere with her choice, nor do I believe it to be in the public interest to create such a right." See footnote 84. He considered that the position might be different if it were in the child's interests that the other man be allowed to contest the mother's choice, but he was of the view that in the present case, the child's welfare was not an issue, in quotes. The judge's view was presumably based on the argument that the effect of the declaratory order sought may not only be devastating for the child, but would also have serious legal consequences for him, since it would deprive him of an existing right of maintenance. See footnote 85. It was accordingly held that the applicant was not entitled to a declaration that the child was born of unmarried parents by having himself declared as the child's father. It is submitted that the view that the mother has the right to choose the child's father should be reconsidered. Today, sophisticated scientific tests can be used to determine with a very high degree of accuracy whether or not a particular man is a child's father. See footnote 86. It would surely be better if the father's identity could be established by a more objective test than only the mother's choice. Furthermore, giving the mother the right to choose the father of her child violates the other possible father's right to equality before the law and equal protection and benefit of the law. See footnote 87. Depending on the circumstances of the case, it may also infringe on the child's right to parental care and the child's right to have paramountcy afforded to his or her best interests. See footnote 88. E. Physical features. The fact that the physical features of the child do or do not resemble those of the alleged father does not bear much weight in proving or disproving paternity. Physical appearance may, however, be considered in conjunction with other factors which prove or disprove paternity. See footnote 89. F. Contraceptives. Evidence that a contraceptive device was used during sex is not recognized as sufficient proof that a particular man is not the child's father. See footnote 90. G. Scientific tests. Point 1. Common scientific paternity tests. Various scientific tests can be used to exclude a person as a child's parent or to show that the person is probably the child's parent. Red blood cell tests can only exclude a person. HLA, that is human leukocyte antigen tests, which are done on white blood cells, can indicate with a high degree of probability whether a particular person could be the parent of the child. DNA, that is deoxyribonucleic acid, desoxyribonucleic acid, tests are even more accurate in indicating parentage. DNA can be obtained from blood, saliva, semen, genital fluids, hair, muscle, skin, and so forth. See Note 91. Point 2. The court's power to order scientific tests in a paternity dispute. Until a few decades ago, scientific tests were seldom used in South Africa in paternity disputes because these tests were not as reliable as they are nowadays. Furthermore, In case of blood tests, the blood of all three parties, that is, the alleged father, alleged mother, and the child, was needed in order to obtain a result. See footnote 92. If the parties voluntarily submitted themselves and the child to a paternity test, the courts were prepared to accept the results as evidence. For example, in Ranjit versus Sheila, see footnote 93, the mother's husband alleged that he did not have sex with her at the time when the child was conceived. Blood tests were done and the results were accepted as sufficient proof that the husband could not be the child's father. In Van der Haast versus Viljoen, see footnote 94, the plaintiff averred that the defendant had had sex with her. The defendant denies this. The results of blood tests corroborated her evidence and showed an overwhelmingly probability that the defendant was the child's father. So just quickly, the meaning of averred is either to state or to... Again, this evidence was accepted. If one of the parties refused to have blood or other samples taken from them or the child, the matter became much more complicated because of the decision in the old case of E versus E, see footnote 95, that the court could not compel anyone to submit blood tests. Nowadays, paternity can be established by using the DNA of the child and the alleged father without any involvement of the mother. See footnote 96. Scientific paternity tests are sometimes even used by the father without the knowledge of the mother or the child, or by the child without the knowledge of either of his or her parents. Despite the increased use and reliability of paternity tests, the issue of whether the court has the power to compel a child and or an adult to submit a scientific test in a paternity dispute remains everything but simple. The legislature could have settled the issue by conferring on or denying the court the power to make such orders, but it failed to do so. Instead, it enacted Section 37 of the Children's Act, which merely provides that if a party to a paternity dispute refuses to submit himself or herself or a child to the taking of a blood sample for the purposes of scientific paternity tests, the court must warn that party of the effect the refusal might have on his or her credibility. This provision is the successor to Section 2 of the Children's Status Act 82 of 1987, which compelled the court to presume, until the contrary was proved, that the person's refusal to submit himself or herself or the child to blood tests is aimed at concealing the truth concerning the paternity of the child, in quotes. Unlike Section 2 of the Children's Status Act, Section 37 of the Children's Act does not create a presumption of dishonesty. It merely compels the court to warn the person of the effect which such refusal might have, in quotes, on his or her credibility. Therefore, the incentive in Section 37 for submitting to scientific paternity tests is weaker than that which operated under the Children's Status Act. See footnote 97. Furthermore, it should be noted that Section 37 applies only to blood tests, even though DNA can be obtained from other material. See footnote 98. In the absence of a clear legislative statement, the courts have been left to deliberate on their power to order children and unwilling adults to submit to scientific tests to establish paternity. In respect of the court's power to order tests on a minor against the wishes of her parent, see footnote 99, most courts have held that the High Court, acting in its capacity as the upper guardian of all minors may order tests provided that they are in the best interests of the particular minor. However, the courts have by no means been unanimous on the circumstances in which such tests are in the best interest of the child. In Sital versus Pravita, see footnote 100, the blood test that was sought could have disproved the paternity of the mother's husband, with the result that the child would have been a child born of unmarried parents and would have been deprived of his right to claim maintenance from his mother's husband. The court held that these circumstances meant that the test would not be in the child's interest. It accordingly declined to order the blood test. In O versus O, see footnote 101, the court declined to make an order authorizing blood tests on the same and other grounds. Here, the applicant was the former husband of the child's mother. He did not dispute his paternity until the child was around 6 years old. The court held that the tests would not be in the child's interests because she and the applicant had a close and loving relationship. It would have a devastating effect on her and her relationship with the applicant if the tests were to show that the applicant was not her father, and she would become a child born of unmarried parents. The whereabouts, financial position, and so forth of the only other possible man who could be her father were unknown. And if the tests were to prove that the applicant was indeed her father, she would resent him if she ever discovered that he had had paternity tests done. In contrast, the court found in M versus R, see footnote 102, that an order compelling blood tests would be in the interests of the particular child whose paternity was in dispute. In this case, an unmarried man applied for an order compelling the child's mother to submit herself and the child to blood tests. The child's mother had married 3 years after the child's birth, and the child accepted and loved his mother's husband as his father. The mother and her husband were planning to tell the child the following year that the applicant was actually his father. For the court, this was the decisive factor. It held that if this disclosure were made to the child and it subsequently appeared that the applicant was not the father, the child would suffer extreme psychological damage, which should be avoided at all costs. The court stated that it was crucial for the child's development and happiness that clarity as regards the applicant's paternity should be obtained. It further held that although taking blood samples would infringe the mother's right to privacy, she should, as the child's guardian, act in the child's interest even if those interests clashed with her own, as happened in this case. In S versus L, see footnote 103, however, the court held that it does not have the power to interfere with the decision of a child's parent not to subject the child to blood tests, even if the court would have come to a different decision. It accordingly refused to order a test against the wishes of the child's mother. Fortunately, the Supreme Court of Appeal eventually settled the issue of the court's power to make an order that scientific tests be done on a blood or other sample from the child. In YM versus LB, see footnote 104, the Supreme Court of Appeal confirmed that the court, as upper guardian of minors, has an inherent power to order such tests in a paternity dispute if the order is in the child's best interests. The court did not give any guidance on the circumstances in which such order would be in the child's best interests. See footnote 105. It did, however, in an obiter dictum, state that it is not always in an individual's interest to know the truth, and that in each case, the court must consider whether it's in the interests of the particular child to know the truth about the identity of his or her father. See footnote 106. The latter statement has been criticized on the ground that it violates the child's rights to know his or her genetic parents or his or her genetic origin. See footnote 107. However, it is submitted that the court's statement is in keeping with the view of the Constitutional Court that a child-centered approach is needed in all matters involving children, and that the court must undertake a close and individualized examination of the precise real-life situation of the particular child involved. See footnote 108. Thus, the court must attach such weight to each of the relevant factors, including the child's interest in knowing the identity of his or her father, as it sees fit, and must ultimately reach a conclusion based on a value judgment as to what is in the child's best interests in the particular case. See footnote 109. Conflicting decisions have also been handed down on the court's power to compel an unwilling adult to submit to scientific tests in a paternity dispute. This conflict has not yet been resolved because the Supreme Court of Appeal did not have to decide this issue in YM versus LB, as it held that there was no dispute about paternity in this case, and consequently, there was no need to order a DNA test. Thus, we are left with the conflicting decisions of various judges of the High Court. In O versus O, see footnote 110, the court stated in obiter dictum that it cannot order an unwilling adult to submit to paternity tests, as there is no statutory nor common law power enabling the court to order an adult to allow a blood sample to be taken for the purpose of establishing paternity. See footnote 111. And then quickly, if we can just refresh, obiter dictum would refer to a judge's expression of opinion that are uttered in court or that are in a written judgment. In Nell versus Nell, see footnote 112, and S versus L, see footnote 113, the courts refused to order blood tests on adults. In Nell versus Nell, the application was based on two grounds. Firstly, the applicant relied on a clause in an agreement between him and his wife, in terms of which they had undertaken to submit to blood tests in order to establish the child's paternity. The court refused to make an order for specific performance in respect of this agreement, inter alia, because the papers before it contained no details of the test to be done on the mother. The court therefore did not know how much of the human body would be removed and from where it would be removed. See note 114. The second ground on which the applicant based his case was that the court has an inherent power to regulate its procedures. On this basis, it was argued that the court could order an unwilling adult to submit to a blood test because the court may search for and collect evidence, which is a procedural matter. See footnote 115. This argument was rejected on the ground that ordering someone to submit to a blood test is not merely a procedural matter, because the order also affects principles of substantive law. See footnote 116, in that the test involves a violation of the person's bodily integrity. See footnote 117. The court stated that it could be very difficult to draw the dividing line between substantive and procedural law, and that where this line could not be clearly drawn, a remedy was probably not available. It further stated that even if ordering a blood test were a purely procedural matter, it would still not grant the order since the test would not be in the interest of the child. See footnote 118. That an order compelling a person to have a sample taken for purposes of a paternity test is more than a procedural issue was also the court's view in S versus L, see note 19, and D versus K, see note 120. In S versus L, the court further held that the alleged father had approached the wrong forum. Instead of approaching the High Court for an order requiring the mother and child to submit to blood tests, he should have proceeded in the maintenance court and adduced proof of the mother's refusal to consent to blood tests in that court. So here the term adduce could mean to cite or to collate. So basically to cite proof. If her refusal were found to be without adequate reason, the applicant could have relied on the presumption in the Children's Status Act that the refusal was aimed at concealing the truth regarding the paternity of the child, in quotes. See note 121. He would then, in all probability, not have been ordered to pay maintenance for the child. It is submitted that this argument is unsatisfactory. Although application of the presumption in the Children's Status Act, which has been replaced by the presumption in Section 37 of the Children's Act, see footnote 122, might have meant that the person in whose favor the presumption operated would not have to pay maintenance, it still would not have answered the question as to his paternity, which might have been the issue he actually wanted to resolve. In M versus R, see footnote 123, the court pointed out that the issue of compelling an adult to submit to scientific tests in a paternity dispute involves conflicting interests. On the one hand, there is the pursuit of truth, and on the other hand, the right to privacy of the person who does not want to submit to the tests. The court concluded that it has an inherent power to compel an unwilling mother to submit to the tests. In this case, the court ordered the mother to submit to tests inter alia because it was in her child's best interest to establish whether the applicant was his father, and because it is the ideal of every court to establish the truth as far as possible. From the discussion above, it is clear that our courts have generally been reluctant to make an order compelling a mother to submit herself or her child to scientific tests in paternity disputes, especially if these tests could prove that a man who is paying maintenance for the child is not the child's father, with the result that the child would lose the maintenance. See footnote 124. This view was correctly rejected in M versus R, see footnote 125, on the ground that money, which is wrongly taken from a man who is not really the child's father, is not a benefit that should be taken into account and to be protected by the court. With the coming into operation of the Bill of Rights, a constitutional dimension has been added to the picture. In terms of Section 14 of the Constitution, every person has a right to privacy, while Section 12, subsection 2 of the Constitution provides that every person has the right to bodily and psychological integrity, which includes the right to security in and control over one's body. The constitutional issue is whether a court order compelling someone to submit to scientific tests unjustifiably infringes these rights. In D versus K, see footnote 126, the view was correctly expressed that an order compelling a person to submit to a blood test would infringe the person's constitutional right to privacy. This remark was based on Section 13 of the Interim Constitution. See footnote 127. The privacy clause in the final constitution is similar to the one contained in the interim constitution. In addition, the Constitution now protects the right to bodily and psychological integrity. Now, an order compelling a person to submit to scientific tests in a paternity suit violates not only the constitutional right to privacy, but also the right to bodily integrity. Section 28, subsection 1, paragraph B, and Section 28, subsection 2 of the Constitution also come into play. They entitle the child to parental care and provide that the best interests of the child must be of paramount importance in every matter concerning the child. See footnote 128. Rendering the child's best interests paramount does not mean that all other constitutional rights may simply be ignored or that limitations of the child's best interests are impermissible. See footnote 129. Instead, the child's best interests must be applied in a meaningful way without unduly obliterating other valuable and constitutionally protected interests. See 130. Thus, the court must weigh up the competing interest of the child and the adult and undertake a proportionality assessment to determine which rights should prevail in each particular case. See footnote 131. Finally, ex parte Emerson, see footnote 132, should be mentioned. Now, ex parte in law is a Latin phrase meaning from one party or on one side only, referring to a legal action or an order or communication that involves only one party in a case, typically without the knowledge or presence of the other parties. In this case, a pregnant woman applied for an order authorizing DNA tests on skin, blood, and muscle samples of a man who had been killed in a motor vehicle accident. She wanted the test to be done to prove that the deceased was the father of her unborn child so that she could lodge a claim of maintenance against his estate. The order was granted, but because of the extreme urgency of the matter, the court did not give reasons for its order. As regards this decision, it has to be borne in mind that the tests were to be done on a deceased person. As is pointed out in Chapter 2 above, a deceased person is no longer a legal subject and therefore has no rights. See footnote 133. The considerations which come into play if a request is made of an order authorizing samples to be taken from a corpse are therefore not the same as those which arise in a case of a living person. For instance, a dead person does not have a right to bodily integrity or privacy. However, this does not mean that anyone who wants to prove or disprove parentage by means of scientific tests may simply remove samples from a corpse, as this may amount to the crime of violating a corpse and may furthermore violate community interests and the feelings of the deceased next of kin. See footnote 134, which might result in delictual liability. So just quickly here to define delictual liability, it would be the obligation to compensate someone for harm suffered due to another person's wrongful and culpable conduct. And this is primarily in South Africa. Point 3. The court's power to take judicial notice of the technique and reliability of scientific paternity tests. A further point regarding scientific paternity tests about which there is uncertainty is whether a court may take judicial notice of the technique and results of the tests. In Nell v. Nell, see footnote 135, the court refused an order for blood tests inter alia because the papers before it contained no detail of the tests to be done, and the court therefore did not know how much of the human body would be removed and from where it would be removed. In contrast, in the judgment of the court, a quo, in S v. L, see footnote 136, Judge Berger was of the view that he could take judicial notice of the technique and accuracy of blood tests. So here quickly, when we say a quo, it's a Latin term or phrase meaning from which. It refers to the court of first instance or the lower court from which an appeal is taken. The full bench doubted whether this approach was correct and expressed its misgivings as to whether developments in the technique of blood testing had advanced to such a degree that judicial notice should be taken of the fact that blood tests could exclude a man as the father with a 99.85% probability of accuracy, and the corollary that if he was not excluded, he probably was the father. So just to end here, corollary in law refers to something that naturally follows. It is a logical deduction or is a secondary consequence of a legal action or a primary legal ruling.